Welcome back to Tech Visa. Quick turnaround. I think.
Very quick indeed.
I mean, we recorded last Thursday, not
Correct.
thinking much would happen up until the weekend.
Yes.
But we woke up Friday morning to a whole bunch of legislation
I
changes.
know.
We never thought that the work experience requirement would be legislated.
Yes.
But we were honestly overwhelmed on Friday to the point where we couldn't really get content out. But we got some exciting updates. One thing I touched on during our last recording was that we didn't have any clarity around the work experience requirement for 482 visa holders.
Correct.
We have received an update.
Yes.
It has been reduced from 2 years to 1 year.
Correct.
And it's official.
It's official. So yes, the all updates or legislation changes happened or took place on the 7th of December.
Yep.
With the formal introduction of the new subclass 482 renamed to the skills and demand visa. The skills requirement right now is degree qualification plus 2 years of relevant full-time equivalent work experience in the last 5. That's going down from degree qualification or formal qualification. It could be a diploma depending on the occupation plus 1 year.
In the last 5 years.
Of the equivalent full-time work experience in the last 5 years, correct. Okay. 5 years cutting back from the date of lodgement.
So that's a big step in the right direction. It's something that we've been talking about for a while, but it's official.
Yes.
We can lodge applications with a degree qualification and 1 year formal work experience moving forward. All right, another update that we received, which is, I didn't really see this one coming, but really positive for visa applicants, is the work experience requirement for PR through the 186 TRT stream. Prior to this update, you had to work for the same employer for 3 years. It then got reduced to 2 years, and then you could apply for permanent residency. Now you still have to have a 2-year work experience requirement, but it doesn't need to be with the same employer.
Correct.
Talk to me a little bit more about this.
The requirements that stood before the 7th of December was that you must have worked in the same nominated occupation but the same employer for 2 years out of any given 3-year period. The short-term occupations were added to that list last year in November.
Yep.
So that meant over the last 12 months, we had a few more cohorts of people who weren't previously eligible for permanent residency. But because there were downtime during COVID or there was changes in employment, we still had people who were on a 2-year 482 visa. For example, your recruiters, your marketers,
Yep.
your events people, advertising specialists, all had to potentially get another 1 year 482 visa to be able to get to that 2-year mark with the same employer. So the rules as of now going forward with the skills and demand and the 186 temporary resident transitional TRT stream is that all periods of sponsored employment
Yep.
is counted. So 2 years, it could be across multiple employers. I think this goes hand in hand with the relaxation of the condition 8607 that was implemented a little earlier, where they moved the 60 days of unemployment to 180 days to allow people to have the freedom or the ability to lodge for a 186 visa without potentially needing another temporary 482 visa.
Just one thing to clarify there, it needs to be in the same occupation. Although not the same employer, you do still need to be sponsored in the same occupation while holding a 482 visa. And you did touch on it really briefly then. You have 180 days to find a new employer. So this has been increased from 60 days, but condition 8607 has been updated moving forward now. Previously, you had 60 days, so 2 months, to find a new employer to take on that sponsorship as well. So we did find that visa holders that did get let go, it was an extremely stressful period for them, where now they have 180 days, which alleviates that stress a little bit more and gives them a bit more time to find a new sponsor.
Correct.
The new skills and demand visa is in place now. The English requirement has been updated. So for the specialist skills pathway and the core skills pathway, we'll have the same English requirements as the medium to long-term occupations that we saw on the temporary skills shortage visas. So you will need an overall score of 5 and at least 5 in each band as part of the IELTS test.
Previously, it was a bit lower if you were to be nominated in a short-term occupation. You can have a score at least 4.5. I mean, look, it's not overly too different. It just makes it consistent. So there's only just one score to be remembered for anyone applying for a skills and demand. That's 5 minimum in each band of the IELTS. I think that's on my head, 36 in each band of the PTE are the 2 common ones.
Yep. Moving on, the temporary skilled migration income threshold.
Yes.
So we have $135,000 minimum for the specialist skills pathway.
Correct.
And then we have $73,150 for the core skills pathway.
Correct.
I think something just to highlight here, we know that part of the 482 program, it did get held at the same number for, I think it was a total of 5 years, and then kind of reassessed after that 5-year period. Moving forward, the TSMIT will get indexed annually. So this is something to be aware of. From the 1st of July every year, this number will change.
What it means is that, yes, indexation is happening annually. It happened last year. So the TSMIT went from 53,900 to 70,000. Again, from the 1st of July this year, from 70 to 73,150.
Yep.
If we keep going with the current rate of CPI or inflation, you'd be looking at what, 75, 76, potentially next year, roll around 1st of July. But yes, that is legislated now. So annually, employers need to be prepared for that salary increase.
And then similar to the English requirement, which was slightly different for the short-term visa holders in comparison to the medium to long-term occupation list, we also have a change in visa application charges.
Correct.
So across the board, it's going to be consistent now for the skills and demand visa. Whether it's the specialist skills pathway, the core skills pathway, it's going to be the same as if you were to apply for an occupation under the medium-term list.
That's right. They used to be a lot lower, about 1,500, but now everyone will be paying the higher visa application charge of $3,115.
Yep.
Plus the department's 1.4% credit card surcharge.
Yep. And is that because all skills and demand visas will be valid for a 4-year period?
I believe most likely that's one of the reasons, and also the wording that the government have been using is that anyone that is to be able to get a skills and demand visa will have a pathway towards permanent residence, which prior, when the short-term occupation list was introduced, was not a consideration. Thus, I think that was the justification of the two different fees. But now there's one fee for everyone.
And then one of the last updates that is significant to what we do at TechVisa, as we do work with startups and scale-ups quite a lot, is a new accreditation pathway specifically focused on startups. So the overarching eligibility criteria is that they have received venture capital funding, and then they can apply to become an accredited standard business sponsor. So before we delve into the eligibility criteria, I want you to talk to me a little bit more about what are the benefits of a business and having accreditation as a standard business sponsor.
Great. The benefits of having accredited status, more streamlined processing. So faster processing. So the department has given us 5 business days as the mandate for any nomination applications if they're not automatically approved on the date of lodgement. So that's very good for businesses that want to compete for highly skilled individuals to be able to have that process quickly. Accredited sponsors can also advertise on their website as one of the platforms for labor market testing rather than relying on 2 national platforms. And the third one I think is most commonly utilized is the ability to issue a letter in lieu of overseas police checks for candidates that are based outside of Australia. So an Australian federal police check is still required if they're nominating a candidate that have lived and worked in Australia for at least 12 months or more in the last 10. But if they're getting someone fresh from offshore, and that person might have been, well-traveled or well-lived across multiple jurisdictions, where if they need to have overseas police checks from certain countries, it could be time-consuming. The sponsoring accredited sponsor can write a letter to say, we vouch to the best of our ability that there is no character concerns. So
this is an excellent way for startups to have access and actually be able to attract those highly specialized roles in that global talent pool as well. Because that's what we do find as well. When overseas candidates are applying for these roles in Australia, they have many other offers from highly reputable companies around the world. And as we know, the Australian visa programs can be very slow. The processing, we've experienced significant delays, but this is going to be an incredible way for startups to access those highly specialized global roles.
Previously,
so
turnover for $4 million for 2 years. It's not something you can achieve as a startup business, but now with a bit more VC funding, I think that'll be very promising.
Excellent. Okay, so we had a team meeting this morning. We kind of debriefed on all the changes. The phone has been going off the hook. I've told the rest of the staff, I was like, any questions you get over the phone, write them down, and we'll do a little bit of frequently asked questions.
Of course.
We've filled an entire document already with questions, so we thought we'd share this with you guys. As we say, these are frequently asked questions in the last sort of 4 hours since this announcement's been made. So straight out of the gates, can I apply for PR through the temporary resident transition stream if my occupation has been taken off the list? And when we say taken off the list, it's not on the core skilled occupation list that we are familiar with now.
Correct. So yes, the wording and the current sort of updates from the department is you will still be able to access the temporary resident transitional pathway of the 186 program, which goes hand in hand with the 482 temporary program, if you can prove you've worked 2 years in the same nominated occupation or sponsored employment, can evidence 2 years of that sponsored employment. So for those that are already on a 482 visa, for example, where their occupations come off the list, if they stay put with the same employer, then technically speaking, towards the end of that 2-year mark, they will be able to be nominated by the sponsoring employer for the 186 PR visa.
Perfect. All right, the next one is, I have changed employers. Can I still apply for PR?
Yes, if your occupation is still on the core skilled occupation list, then technically speaking, no issues. As long as you get 2 years of sponsored employment, then you will have the pathway towards the 186 TRT. Not sure if it's one of the questions to follow, but if you are able to get a skills assessment in one of the occupations on the core skilled occupation list, you now also have access to the 186 direct entry pathway, which previously was not available to a lot of people. So that's something to consider as well. And I've already had one person that have been positively impacted by the changes as their occupation was added to the core SOL. They previously done a skills assessment for the 190 program and have more than 3 years of experience, can now technically be sponsored by the sponsoring employer or by their current employer for the 186 visa via the direct entry pathway.
So I have lodged a 482 TSS application. It's currently pending. How will the new changes affect me?
Don't think it'll be impacted based on all the wording on the policy guidelines we've been given. So as of the rules before the change occurred from the 7th, so anytime before the 7th of December, you've lodged a 482 visa, it's still pending. It will still be assessed based on the rules or the policy procedures at that time. So basically just wait for a decision from the department. It's not that if you were nominated in an occupation that was not added on the core skilled occupation list, that you would automatically be refused a 482 visa. That would not be the case.
So essentially, your application will not be affected by the recent changes.
Correct.
A little bit of an obscure one. I don't know how many of these we're really going to see, but we have already had one question around this. So if there's a pending nomination application that was lodged before the 7th of December, but the visa application is yet to be lodged, how do we deal with this moving forward?
So we actually have a couple as a firm where we got the nomination in because we were made aware of the core, so 2 or 3 days before the implementation date, where the nomination was kind of processed and then lodged against the department legislative requirements. So the department has come out with their explanatory statement saying that the visa can still be linked to the nomination, as that's recognized by the legal provisions that's currently in place. So that means our recommendation is, if you can get your visa organized, get that organized and have it submitted against that nomination. If you wanted to be a bit more risk averse, we can wait for the nomination to be approved, and then within 12 months of the approval date, still lodge a visa against that approved nomination.
Yep. All right, moving on. So I hold a 482 visa. I want to change companies, but my occupation is no longer on the core skill occupation list.
Yes.
What do I do?
There will be some that's in this cohort. I'm hoping it's a very small amount of people. So if you are paid an annual salary of $135,000 or more, technically speaking, you should be able to lodge a nomination under the specialist skill stream. Yep. But if you paid less than that or work in a trade occupation that's not covered by this specialized skilled occupation or stream, then unfortunately you cannot change employers, or there's not an option for your new employer to lodge a nomination if your occupation is not on the core SOL.
Yep. Is the core skill occupation list applicable to 189 and 190 visas?
No, it is not. Only for the 482 and the 186 direct entry.
Thanks for your time.
You're welcome.
Thanks for tuning in to another episode of Tech Visa. Be sure to subscribe to our channel for all the latest migration updates. Until next time, bye.
Bye.